What's new from the appellate division? Stay tuned for the legal scoop. So it's not every day we get a decision from the Court of Appeals addressing workers' compensation. If you're not familiar, the Court of Appeals is basically the New York State equivalent of the Supreme Court. But we did get a decision in Aungst v. Family Dollar addressing COVID-19. So the facts of this case are basically your typical COVID claim. Claimant worked at Family Dollar. He was exposed to the public during the COVID pandemic. He wasn't social distancing at work, and he wasn't provided with PPE. There also wasn't a lot of evidence that the claimant was exposing himself to COVID outside of work. So the issue here was that the carrier and self-insured employer side of the bar finally got to challenge the Prevalence Standard, which is how the board's been establishing comp claims for COVID since the COVID pandemic started. And we've taken issue with this because prevalence, which basically says if you can demonstrate that COVID was prevalent in your area and where you work at the time of the contracture of COVID, and you can also show that you were being responsible outside of work as far as COVID, then you can get a COVID claim established. And we've taken issue with this because that was never established by law and it was never promulgated by the board through a proper rulemaking process. However, the Court of Appeals upheld the prevalence framework and it's now the law of the land. And basically what they said is it's not inconsistent with how we've addressed similar claims for, say, tuberculosis, other communicable diseases where, for example, there was one claim for tuberculosis where the claimant could demonstrate that there was persistent coughs by an inmate, and around that same time he developed tuberculosis, and the inmate was known to be positive for tuberculosis. So now prevalence is the law of the land. So what does that mean for your cases? The answer is probably very little. At the time of the pandemic, a lot of employers were exhaustively testing their employees and contact tracing. Nowadays, that's really not very common. I don't think many of us see that anymore. So demonstrating prevalence will be a lot more difficult for claimants to accomplish. So while we're disappointed that the prevalence framework is now the law of the land, again, the impact this will have on your claims is probably very little. Want to stay up to date on all decisions from the appellate division? Stay tuned for next month's Legal Scoop and subscribe below.